Hello and welcome. Today we will talk about Chapter 11, Grievance and Disciplinary Procedures. This chapter gives you information regarding the steps to a grievance procedure, functions of grievance procedures, employee misconduct, disciplinary procedures, grievance mediation, and public sector grievance issues and how they relate to the private sector. What is grievance? Grievance could be any formal complaint that is filed by a worker or an employee or union concerning any aspect of the employment relationship. A grievance is generally a perceived violation of a contract provision. There are many steps in the grievance procedure. So there could be employee and supervisor, just simply talking about what the violation was and taking care of it there. You can have written grievance procedure that is documented and sent to the employee, to the human resource department, and to the union members. You can have a discussion with the department head, go above and beyond your immediate supervisor, all the way to the top manager. And you can have union grievance committee, director of personnel in industrial relations, all talking about this procedure. Or as a final step, you can have arbitration to bring a resolution between the employee and the managers in respect to the specific violation that is part of the grievance. The functions of grievance procedures could include conflict management resolution, agreement clarification, overall communication between the employee and the manager, or the managers, strength enhancement, in due process for the employee who is being accused of, let's say, a specific unfair practice or not performing according to the contract or to the expectations. So due process is part of the job security. We mentioned that is the legal requirement that the state and the organizations must respect all legal rights that are owed to an individual worker or employee. Due process, again, tends to balance the power of the law of the land and protects the individual worker from those laws to make sure the laws are applied fairly to all workers. So what is employee misconduct? Employee misconduct basically has a wide range of issues. Some of them can be very serious, like fighting or even threatening another employee with violence, or they could be minor issues, such as basically forgetting to punch in the clock or recording your time properly. Serious offenses warrant, in some cases, immediate discharge or termination of the employee without the necessity of prior warning or attempts to correct the action. So there's no need to have corrective action steps when there's a serious senior misconduct. However, minor offenses call for attempts at corrective action and do not call for immediate discharge of the employee based on the first offense. So minor offenses call for attempts to have a corrective action, and they do not necessarily require that you discharge or terminate an employee immediately based on the first violation or offense. Arbitrators do decide employee misconduct cases on the basis of management's consistent enforcement of the pertinent rules to all employees, management's compliance with the contract's disciplinary procedures, in the employee's work history, and finally the employee's length of service with the company or overall tenure. With regards to minor offenses, the penalty for the minor offenses determined usually by how often a violation has occurred. And there's usually the progressive discipline process for minor offenses, like in the first offense, you have an oral warning to the employee, you have a discussion with him or her. In the second offense could be a written warning for the employee. The third offense could be a second written warning and suspension without pay for a day, for a week, for 2 weeks, depending on what seems to be fair and according to the contract. In the fourth or final progressive discipline would be that you terminate or discharge the employee because he or she has not corrected the specific violation or his or her behavior. So usually the incident of the violation or the discussion, whether it was written or oral, tends to be removed from the employee's record if it is not repeated after a certain period of time. When I was a corporate manager, I used to tell employees, for example, for a minor violation of, let's say, not punching in the clock exactly when they were supposed to. They punched in, let's say, 20 minutes later, and they said they forgot to punch in the clock. So when it wasn't repeated for, let's say, 6 months or so, I would remove the record of the discussion or that violation from the employee's file or records. So it's a good idea to provide a motivational incentive for the employee to correct the behavior and obviously not penalize the person for future promotional opportunities. For serious offenses, you should know as managers and employees should know that certain actions can indeed lead to immediate termination or discharge, even in the case of the first violation. However, the managers and employees should know that the discharge must be for just cause. Serious offenses are usually identified in the contract and negotiated as part of the bargaining agreements. Arbitrators do expect both parties to carefully adhere to the letter in the spirit of the contract or the spirit of the law. Some of the common grounds for immediate discharge of employees could include unsatisfactory work performance, unauthorized absence, insubordination, dishonesty or even theft of employer's property, failure to follow safety rules in the organization where other people's safety is in jeopardy or the employee's own life is in jeopardy, impaired work performance due to the influence of usage of drug or alcohol when a person is working, conviction of job-related crimes, workplace violence or the threat of violence, unauthorized strike participation, violation of work rules, etc., etc. So there could be many reasons why you would basically immediately discharge an employee. So managers should know it and employees should know what they would be discharged for immediately if they make the first violation in the workplace. There's also the last chance agreement. So the last chance agreement is that when an employee's misconduct becomes unacceptable, there's usually a last chance agreement, otherwise known as LCA, last chance agreement, among the employer, the union, as well as the employee. So the last chance agreement is negotiated between all three parties that after this, a termination is definitely coming for misconducts. In regards to the general disciplinary procedures, they can include processes that are usually designed to set the standards of performance, as well as obeying the work rules, and to apply the discipline all the way up to the termination process when those standards are not being followed in a fair and consistent manner by employees in your department or in your organization. So the general purpose of the procedures is to reduce the number of violations among employees so they can basically perform according to the standards and obviously not violate any rules that would jeopardize the safety of your employee, your colleagues, your department, or your customers. Disciplinary investigation procedures could be explaining the company rules, getting the facts, ascertaining the motive of why there's a disciplinary process, considering the employee's past records, disciplining without discharge, in acting in a timely manner to make sure certain violations are not repeated. This way it does not lead to termination, especially if it's a minor first offense. In the case of grievance mediation, the use of a natural third party is the first step in grievance procedures. The mediator, usually in a confidential process, facilitates the parties developing a resolution of the grievance themselves and thereby avoiding arbitration. So mediation is something that precedes arbitration. Arbitration can be much more costly, so therefore all parties tend to avoid it. The advantages of mediation could include faster resolution of issues compared to arbitration. Both parties may present their case to the mediator. It enables both parties to reevaluate their cases before proceeding to arbitration. Also, the federal mediation and conciliation services do provide a service, oftentimes without charge, in the United States. The use of grievance mediation in comparison to arbitration usually means there's cost savings, there's time saving, satisfaction with the process among all parties involved, and increased ability to resolve the grievance in a short period of time. In terms of public sector grievance issues, public and private sector grievances are processed in the same way. At the federal, state, and local levels, grievance arbitration procedures are very similar to the private sector as well. Grievance arbitration has proved to be more useful means of contract enforcement than having strikes. Expense of grievance arbitration is usually a concern, and the relationship between the parties determines the amount of disagreement regarding contract interpretation. But usually all parties obviously want to avoid arbitration, solve their issues among themselves or through mediation. This way, both employees and managers resolve the issue faster and with less cost. For discipline and dismissal, usually government employees are afforded constitutional protection. Disciplining or dismissing a government employee is a form of a state action. So constitutionally protected acts include, number one, privilege against self-incrimination. Second, freedom of association. Third, right to participate in partisan politics. And fourth, freedom of expressing yourself. So these are constitutionally guaranteed rights for employees, and therefore managers have to be very cautious when they are disciplining employees. As a summary for this chapter, let's look at some tips from the experts. So what are some of the best ways to ensure a fair grievance process or procedure if you're the union or the employer? First of all, conduct a full and adequate investigation into the facts and circumstances for the given grievance or situation. Give the employee an opportunity to explain why he or she should not be disciplined, or the employer the chance to explain why the discipline imposed did not violate the agreement or past practice. Second, make full disclosure at the earliest possible grievance step. Disclose the issues, the facts, the documents to be presented, and the names of the witnesses and what they will offer as a testimony. And third, do not rely on the other side to make the case for you. Develop a theory of the case with witnesses and documents ready to support your side or your perspective. So you can be a fair manager, a fair union representative leader, or a fair arbitrator in the grievance process. Hear the employee's side, have documents, make sure you go according to the law, according to the contract, and provide a good chance for resolution of the process without having mediation or arbitration. Try to solve this through a good, ethical, and fair process between you and your employee, between you, your employee, and union representative, or through mediation. It takes time, but you can reduce some of the stress and anxiety on everybody's part by being fair and having good intention to correct the problem as opposed to simply terminating the employee. Good luck.